Welcome everyone. Thank you for joining us. I'm Nikki Jovicic from LookUpStrata, and for this New South Wales Q&A webinar session, I'm very happy to welcome Leanne Habib, founder of Premium Strata. Today we're discussing everything New South Wales Strata. Leanne will talk to you shortly about the rollback of the COVID-19 Strata amendments in New South Wales and what this means to you, and then we have quite a few submitted questions to discuss. Please feel free to share this recording with neighbours, committee members, other staff members, or anyone you think will be interested in the session. Before we begin, I'd like to mention that the information contained in this session, including the discussions that arise from submitted questions, is not legal advice and should not be relied upon as legal advice. You should seek independent advice before acting on the information contained in this session. I'm delighted to introduce our panellists today, Leanne Habib from Premium Strata. Leanne, the founder of Premium Strata, is a licensed strata and community manager and a real estate managing agent with 23 years of experience. Having previously worked in various senior management roles with large strata and community agencies around Sydney, Leanne created Premium Strata in 2007 and its sister company, Premium Building Management, in 2015. Leanne is often called on to contribute her expert opinions on articles, industry changes, and topical industry matters. She's also a regular contributor to strata questions from lot owners in New South Wales on Australia's top strata living blog, LookUpStrata. Sydney's prominent schemes seek Leanne's guidance, knowing her experience, attention to detail, and passion for policies and procedures will ensure the foundations of any scheme are robust and fit for purpose. Her years of experience afford her a unique ability of looking at challenges from all perspectives, developer, consultant, future owners, and proposing a viable, practical solution. As mentioned, Leanne is certainly a regular contributor to LookUpStrata. What many people may not be aware of is the fact that Leanne was our very first person to come on board to assist us with Q&As. I believe that was around the beginning of 2015. Since then, Leanne has responded to hundreds of questions. Leanne appears in over 80 articles on the LookUpStrata site, and almost all of these articles contain multiple responses. Just one of these articles has received over 3,500 reads in the last 30 days. I'll leave you with Leanne to walk you through the changes to the rollback of the COVID-19 Strata amendments, and I'll join you in a little while to cover the Q&As. Welcome, Leanne.
Thanks for having us. It's a pleasure to be here and contributing further. Appreciate the opportunity. But I think everyone will recall around about May, when it was a peak in COVID, May 2020, amendments were made to relax the requirements for convening and holding strata meetings and extending the usual time frame for compliance with the Act, such as when you could call the first annual general meeting after the initial period expired. And just when we borrow funds from the Capital Works Fund to the Admin Fund, you generally had 3 months to repay that back. That got extended to 6 months. This was then further extended in November, from November 2020 to May 2021. But now it's all come to an end. There's only a couple of things that have remained in place, and these changes were revoked as at the 12th of May this year. So some of the amendments that still remain in place are notice of any meetings can still be served by email, which is great because I think it's a more convenient way to serve notice on owners. And audio-visual of a fixation of the common seal and witness provisions still remain. But what has been removed from these provisions are the alternate means of voting. So electronic voting, via Zoom, conference, etc., can no longer happen unless the Owners Corporation or Strata Committee has passed the necessary resolutions to permit same. But all extensions of time periods have now been removed. So first AGM now must be convened in 2 months as opposed to the 6-month extension. So these changes only take effect from the 12th of May. If there was a meeting that was scheduled and convened prior to the 12th of May, that would remain. You can still hold that via Zoom if that was the preferred method. It's just any meetings that are convened from the 12th of May and onwards that these rollback changes would apply. So that's a high-level summary of what the changes entail. I think it was great while we had those amendments and relaxed changes. It allowed everyone to get on with their strata meetings during the peak of COVID and the restrictions that all applied. But I think it's come to an end, and hopefully a lot of owners corporations took opportunity to pass the resolutions that they needed to have the Zoom meetings, the video conference, because I think it is a very, very good, convenient way to hold meetings. It saves owners rushing from work, getting to a location. It's a lot more convenient to hold those meetings generally from the lounge room or from the office. I think the larger meetings were definitely a challenge. I think our preference is definitely to hold those larger meetings in person. I wouldn't want to struggle with a 400 lot scheme over Zoom. So I think for the smaller, simple meetings, it's definitely ideal, but it's great to be able to be back, holding meetings in person for the larger schemes, definitely.
Excellent. Thanks so much for that wrap up, Leanne. And we have heard that other strata managers feel the same way about the larger meetings as well, by the sounds of it. So I think, yeah, that's a common feeling. But yeah, it's great that to know that and to get that update for me. So thank you very much for that information.
Sure.
Okay, so what we might do now, we've had, as we mentioned, quite a few questions come in. Please feel free to submit anything if you've got questions that you haven't submitted to us already, and we'll see how we go with getting to that during the session. That would be dependent on time, of course, but we'll run through the questions that we've had submitted. So I'll just start with that now. The first one. The owners removed the carpet in the apartment above mine without permission. Our strata plan has the basic standard floor coverings bylaw. I've raised my concerns with the upstairs neighbour and they got and are still quite angry and resentful with me. They have laid rugs in the high traffic areas and this has helped cut down the noise of footfall. However, the situation is still nowhere near as effective as when carpet with acoustic underlay existed in that apartment. I still hear them walking around and the creaking of floorboards, which I did not hear before. Is there anything further I can do or do I just have to put up with it?
Yeah, so you definitely don't have to put up with it because Section 153 of the Strata Act talks about creating a nuisance. So another resident can't create a nuisance that interferes with the peaceful enjoyment of another lot. I would suggest first raising it with your strata manager, but it's not only the noise bylaw and Section 153 that you can rely on. So there is a noise bylaw, putting aside the floor breach, if there is a breach, you've got the noise bylaw that states that you can't create a noise disturbance. And you've also got Section 153, which means you can't create a nuisance to another resident. I would probably first be raising it with the strata manager, having them pursue it and enforce both Section 153, the noise bylaw and the flooring bylaw. But I'd probably also, if you were to pursue it further through NCAT, I'd probably be looking at engaging an acoustic consultant just to ensure that the tolerance of noise isn't acceptable and within the BCA compliance, because there is a certain tolerance of noise. Some people can just be more sensitive to noise. So before taking it further, I would definitely look at getting an acoustic consultant to see whether or not the noise level coming from that unit is acceptable or not. But the short answer is no, you don't have to tolerate it. You've got the noise bylaw to rely on as well as the flooring bylaw, but you've also got Section 153 of the Strata Schemes Management Act, which talks about, not creating a nuisance to another resident.
Okay, and they mentioned in there that they did approach the resident upstairs and have a conversation with them. Do you think that's a good action?
Look, sometimes it is because some people sort of, react getting the formal approach through a strata managing agent, but sometimes it can work the other way where they can still take it, get offended because you've approached them. So I think you've approached them firsthand, you've tried that nice approach. I think you now need to run that through the formal channel, and that's generally through your strata managing agent and your strata committee, because they do have an obligation to enforce compliance with the bylaws. And if it can be proven that there is a breach of bylaw, then I would definitely be running it through the strata managing agent.
Okay. All right, we'll move on to the next one. Should legal representation be obtained by an owners corporation before applying to NCAT for the hearing of failure to comply with bylaws? At an NCAT hearing regarding continued failure to comply with bylaws and after serving a New South Wales Fair Trading notice to comply, is it usual for the applicants, the owners corporation's legal costs, to be awarded against the offender along with the $1,100 fine?
So to answer the first question, is it suggested to have legal representation? In NCAT, you have to actually seek leave to have legal representation. So it's not automatic. You have to actually get approval from the tribunal member to have representation. If representation is approved, generally NCAT is a jurisdiction where there's no cost, but you can obtain costs on rare occasions and circumstances, but generally speaking, no, it's no cost. You can't seek your cost. I would always recommend, however, having legal representation, especially when it comes to enforcing bylaws, because sometimes it can be a straightforward, they've breached that bylaw, but it can be a technicality, or sometimes how the bylaw has been worded doesn't actually assist the case either. So my strong advice to a lot of our clients is to seek legal advice on the bylaw to ensure that it's worded in a format that can be enforced to the intent. And having that legal advice initially will ensure that if you do take action against that lot owner for breach of that bylaw, that you're going to have a stronger position in enforcing it and winning in NCAT. So for me, I always generally encourage having legal representation, but you do need to get the leave from tribunal, and it's not always guaranteed that you would get cost. In most cases, it's unlikely that you would get cost. You have to prove that the application was lacking in substance and etc. for you to actually obtain any cost order. And generally, if the tribunal member, if you've got two parties, let's say you're the applicant and the defendant doesn't want to have legal representation, it's very unlikely that a tribunal member would award cost in your favour against that defendant because they didn't have any legal representation, especially if you were the applicant that was pushing to have legal representation.
Okay, thank you, Leanne.
That's okay.
I think my strata manager is withholding some of my levy notices. They say I'm unfinancial, therefore I could not vote at the last AGM. I've sent 3 emails asking for the levy notices that I'm missing. How do I ensure these late notices are sent to me as the strata manager is ignoring my emails?
Okay, I would definitely put it in writing if you haven't already. And when you do put it in writing, I'd be giving a reasonable timeline for compliance, i.e. a timeline for that strata managing agent to respond. If you feel that they haven't yet responded, then you would need to take further action, and that is to apply to NCAT. Your first step is mediation. I just wanted to note, however, Section 83(4) of the Strata Schemes Management Act doesn't actually require a strata managing agent or the delegated treasurer of an owner's corporation to issue a levy notice, although it's standard common industry practice that you would be served a notice every quarter reminding you and prompting you of the amounts due and payable, but it's not a legal requirement under the Act. So not receiving a notice would not be a reason to not pay the levies. So I do support that you should be writing to the strata managing agent, putting it in writing, giving them a reasonable deadline to respond. And if they haven't responded, I will then make application to tribunal. The mediation is the first step, and I'm confident that when they receive an application for mediation that they would respond. Others, I'd need to give reason as to why they haven't responded. Another option is if your managing agent does give you access to their portal. Generally through the portal, many strata managing agents that give access to their clients, you could actually uplift a levy statement through that portal. So if you don't already have access, I would make inquiry if you can have access to the portal, obtain your login details and try uplifting the levy statement through that portal as well.
Excellent. Okay, I live in a block of units that has a resident who is a long-term compliance cop. The person's always taking pictures of what they consider to be against the rules and formally complaining. I think the term frivolous litigant would be a good description. There's no hesitation to bring fair trading into any dispute. Recently, this person was voted onto the committee, and that gives them the feeling of justification in ensuring everyone's following the rules to the letter and no excuses are accepted. And they then use the owner's corporation to pursue whatever is the latest sin. The term playground bully comes to mind. Can this person be removed from the committee before an AGM if the residents agree? I say residents as I'm not sure how the committee feels about this. I believe they should be looking after everyone's interests in a compassionate manner, not ramming the rules down our throats. My belief is we live in a community and there should be a bit of give and take.
And look, I absolutely agree. I mean, when you're living in strata, I always say it's community living. You've got to have a level of tolerance because you're sharing common walls, floors and ceiling. There has to be a level of tolerance when it comes to accepting some noise, some, behaviour issues to some extent. Obviously, bylaws are there to keep the house in order. It's a bit like having cars on the road and having no road rules. Our cars will just be out of order. It's the same thing in a strata scheme. We've got to ensure that we have rules, we enforce them when required to ensure that the house remains in order. But I do understand the point because you do get some that sort of, take it very serious and sometimes enforce it beyond necessary. But the short answer is yes, you can remove this committee member. It's not a decision of the committee, however, to remove a member of the committee. It is definitely a decision of owners at a general meeting. It does require a special resolution. So you would need 75% in favour and no more than 25% against to successfully remove this particular committee member from the committee. So you'd have to take steps to convene a general meeting. And there's 3 ways to convene a general meeting, either by majority vote of your strata committee. The secretary has the power to call it, or if you get requisitioned, and that is 1/4 of the unit entitlements, request that a general meeting be convened. And if a general meeting is successfully convened, that is the meeting where you would consider removing that committee member. And as I said, you need 75% in favour. So you'd have to be sure that you'd have that support and vote, because it is a big threshold. It's not your stock standard ordinary majority resolution of 50%. It's a higher threshold. So you'd want to make sure that you do have a lot of owners that do support the removal of that committee member.
And if they did go ahead, Leanne, and they weren't successful in removing the committee member, are there other ways to manage that situation if the committee member does stay on the committee?
Yeah, I think if the other committee members aren't in support, because I always say often to a lot of clients that, you know, one committee member is one voice. No committee member has a casting vote. No committee member is the, you know, the one that makes the final decision in any way. So whilst that one committee member is raising things, it just goes back to the managing agent or to the other fellow committee members not acting on one instruction. They should only be acting on the majority decisions of the Strata committee. So for me, if I had one that was giving me direction, I would be saying, okay, noted your position, Nikki, thank you. Can I have responses from, you know, Andrew, Paul and Jane? Do I have a majority decision and instructions to proceed by issuing a bylaw breach letter to Unit 1 for X bylaw? So I would definitely be encouraging this owner or this particular committee to only act on the majority of the committee instructions. But again, going back to a general meeting, but this particular owner can requisition a general meeting and have any decision of the Strata committee overturned. So that's why notice of a Strata committee meeting has got to be made aware to owners so that they are aware of the decisions that a committee would be making a decision in relation to. So if they do disagree and they can collate enough votes, they can then take that matter out of the hands of the committee, take it to a general meeting and have the general meeting decide accordingly. So in short, yes, they should act on a majority decision of the committee members as opposed to one member who might be the dominating member, or two, they can take that particular subject out of the hands of the committee and take it to a general meeting for a decision.
Okay, and the next question is similar to that, although there's a few points of difference, but we might cover that now. At our monthly Owners Corporation meetings, although the whole committee, including the chairperson, attended, the meeting was run by our overbearing secretary. We've been told that the secretary runs the meetings because the chairperson is inexperienced. The secretary takes full control, will not let anyone make any comments or ask any questions. We're feeling very bullied by this person. What can we do?
Okay, I always say there's one in every scheme. Generally, there's one that is very passionate and, you know, likes to take control. My view is a very black and white view. The secretary has its role and the chairperson has its role. It's not for the secretary to fulfill the role of the chairperson. So the chairperson at any meeting has first right to chair the meeting and must if they preside at the meeting. It's not even optional. So under the Act, it basically states that if the chairperson presides at the meeting, they must chair the meeting. If the chairperson is not present at the meeting, then the members, being a majority of members, need to nominate another member to chair the meeting. So it's not even for the secretary to step in as a backup, unless you had a delegated chairperson, which could generally be the Strata managing agent. If they're at the meeting, then as delegated chairperson, they would step in to chair the meeting. But if both the appointed chairperson and the delegated chairperson were not present at the meeting, then the members would need to nominate a chairperson if it was a committee meeting. If it was a general meeting, the owners, being a majority, would nominate a chairperson. So my advice is that the secretary should be reminded of its role, and that's outlined under Section 43 of the Act. Section 42 of the Strata Schemes Management Act sets out the functions of the chairperson, and the main function is to chair a meeting. So my view would be irrelevant if that chairperson is incompetent, not capable, it is their role, and until they're reappointed with another office position, they are to take that position as chairperson. So again, similar advice to what I gave on the previous question. The majority of the committee members should be saying, well, no, Nikki is the chairperson, Nikki should be chairing this meeting. So I think it's taking that strong stance that everyone should fulfill their role. And as secretary, you have a role to fulfill, but as chairperson, they equally have a role to fulfill.
Okay. What are the voting rights on a strata motion midway through the unit sale process when contracts have been exchanged but are yet to be settled? Who's the voting party under these circumstances?
So the registered owner at the time of the vote being conducted. So if you and I, Nikki, have bought an apartment, we've exchanged, I'm the incoming purchaser, the settlement's not due till September, a meeting is held in August, you will have the vote as the current owner. I don't become an owner until I have settled. So it's the registered owner on the strata roll at the time the vote is conducted, being the time that the meeting is convened.
Okay. We've just had a really quick, we'll cover some of the questions that have come in as comments a little bit later on, but one of them has just come in. It's a really short one and it relates to a question that we've just read out. So I might just go to that one quickly. Is the chairperson elected before the meeting for each meeting?
So generally at a strata committee meeting, so at a general meeting, you elect your strata committee, but you don't elect the office bearer's position. That is done at committee meeting. So generally at your first committee meeting immediately after the annual general meeting or shortly after, you would elect office bearers. If you've elected office bearers, they would hold those positions until they are removed from position. But if you haven't elected a chairperson, secretary and treasurer to remain in office for the term of their appointment, which is generally up until the next annual general meeting, then you can elect a chairperson for each meeting. But it's highly recommended that you elect these office bearers' position to remain in place up until the next election, being at your next annual general meeting. I think it's important to have office bearers' positions. Even though you have a managing agent in most cases, there are still schemes that are self-managed, but where you have a managing agent that is appointed, you still need to have members of your committee have those functions and duties in case you need to do something where you don't require your managing agent, or in fact, you might be wanting to terminate the services of your managing agent. So I think it's critical that as office bearers, you hold those positions as well so that you can be independent in calling a meeting if you need to, issuing correspondence to owners if you need to. I think it's critical. And that's why at all our annual general meetings, we ensure immediately after we elect office bearers at a committee meeting. So I'd highly recommend that you do elect office bearers positions to be for the term of their appointment and election, as opposed to randomly at each meeting when it's held.
Okay. Our strata is an over 55s or invalid property. Can a purchaser be blocked from buying a lot if they're unable to prove they are 55 or more years old and or permanently invalid, a permanent invalid? Finally, what constitutes invalid under strata legislation?
Okay, so the first question is, it's not the purchaser that needs to be 55, it's actually the resident. So I could actually purchase the property and have my mother who's over 55 reside in the property. So the deciding factor is on the resident as opposed to the purchaser. So the purchaser can be any age, it's just the resident that presides. If you're a resident, however, and you're 55 and you have a relative, whether it be, a dependent child, be, an aunt, a stepfather, etc., and they are under the 55, they can also occupy the property with you as the over 55. So it's the main resident that needs to comply and be 55. What determines whether, you have the disability, etc., to actually reside? I probably wouldn't have a go at guessing that because it will come back down to medical reasons. But I know that you can go to the Retirement, I know the Retirement Village Act will set out more on that. But for me, in short, it would be having some medical certificate to confirm that you do have, a disability or a condition to ensure that you, do warrant what they define as acceptable.
Okay. Now this one is to do with a self-managed complex. How do we force a decision in a 4-unit self-managed complex? There are always 2 for and 2 against.
They're the fun schemes, I say, and as I say to a lot of clients, generally a 4-lot scheme can create more work than a 400-lot scheme because of that one reason where you just continue to get it to deadlock. So it's very common. I always say strata is a democracy. It comes back down to a vote. And unfortunately, when you're in a 4-lot scheme, you can't get that majority vote, you're in a deadlock. I basically say that if the decision relates to something that is an obligation of an owner's corporation, so if it's, requirement to repair common property, which is a requirement under Section 106 of the Strata Schemes Management Act, then you can force a decision through NCAT. But if it's a deadlock decision on something that is not an obligation of the owner's corporation, then the matter remains unresolved. You could take it to NCAT, but you're going to have grounds on why you're forcing it. I'll give some examples. So if there was a failed, membrane and it was leaking, and you got a deadlock where 2 wanted to repair the membrane and 2 didn't, it's a deadlock. I would definitely take that to NCAT because an owner's corporation has an obligation to repair that failed membrane under Section 106. So it's not really a choice. It's something that you have to do, i.e. it's an obligation. And I think you'd be successful in having that pursued in NCAT. If on the other hand, it was like, we think that the carpets are dated although they're in good condition, but they're dated, we actually want to replace carpet to tiles in the lobby. That's for me an upgrade. That would be very difficult to force upon other owners that are against it, because that's more of an upgrade as opposed to an obligation. So I think the short answer is, where you feel that the decision is an obligation of the Owners Corporation to meet their obligations under the Act, repairing and maintaining, or any other type of obligation, you can force that decision through NCAT. But if it's a simple decision about wanting to upgrade or alter common property in any way just to enhance the common property, then I don't think you can enforce that decision. And unfortunately, it's a democracy. You don't have the votes. It ends up being a deadlock. The matter remains unresolved.
Okay. This one is an interesting one. Our strata plan has all tiled and paved areas within each private lot's garden. They're designated as common property, presumably for consistency. After 20 years of wear and tear, they are degrading, and some lot owners want to replace the tiles. The original tiles were discontinued many years ago, so a match is neither possible nor desirable. As the tiled areas are not visible from the exterior of the building, generally, can the strata plan be amended to release these areas from their common property restriction?
Definitely. So there's two ways you can do that. You can do that by passing a resolution, which is under section 106(3) of the Strata Schemes Management Act. And that's where an owners corporation just passes a resolution to de-invest itself from being responsible to repair those pavers. They can only do that, however, if those pavers, if they're not maintained or not renewed or replaced by any party, they don't impact the function of the common property or another lot within the scheme. So you can only do that if not maintaining it doesn't create an issue for another lot or doesn't cause any impact on the common property. So that's one step where you pass a resolution. The second step is passing a bylaw that actually makes these pavers the responsibility of the lot owner for those lots. I would probably recommend doing both, because we do both for our schemes. We would always pass a bylaw to say that, X units are responsible to repair and maintain the pavers. But to add further clarity, we would pass that resolution under section 106(3), where it states that the owners corporation is de-investing its responsibility to repair and maintain those pavers as well. So yes, you can make them lot owner responsibility. The purpose of having the bylaw is to ensure that it's registered on title, because the bylaw is the only mechanism in which the owners corporation can transfer its responsibility to repair and maintain common property onto a lot owner. That becomes a bylaw that is registered on title, and the bylaw is attached to the lot as opposed to the owner. So if I was to sell my apartment to Nikki, then Nikki, who would do her diligence prior to buying, you would then search on title, you would see that there's a bylaw, you would know that if you buy unit 1 in strata scheme XYZ, you are automatically made aware that the pavers in that courtyard are now your responsibility as the lot owner to repair and maintain. So that's why bylaw, in my view, is critical. It ensures that incoming purchasers are aware of their obligations. Because if you just do the first step that I mentioned, that just means the owners corporation is not responsible, but it's not pushing back responsibility onto the lot owner of that lot to maintain and repair those pavers. So I think two steps are important. One is to ensure the OC are not responsible, but the bylaw is to ensure that someone else is responsible so that the tiles don't become dilapidated and left unattended to.
Okay. This one is to do with access into a lot. As a new owner, my building manager charges $140 per access card, and I require 4. The 2 access cards provided by the previous owner have been deactivated. My family of 4 are moving into a 2-bedroom unit on the 50th floor. I understand extra charges would apply if I lost my card or need extra cards, but I can't actually access a lot without the card. So is it reasonable for them to charge $140 per card?
So the owners corporation will generally apply a fee for a swipe or a key that accesses common property. So the short answer is they can't restrict access to your lot. So keys to your lot are within your jurisdiction and your responsibility. The owners corporation can only govern and control swipes to the common areas. Generally, it's very common practice that an owners corporation will apply a fee to that swipe to the common areas, and by default, you obviously need that swipe to get into the building to then access your lot. So it's very common, yes, they can. If you, however, don't have any key at all, that I would be going back, if you're a purchaser and a new owner, I'd be going back to your vendor to say, well, I need a swipe to access the building and the property that I've just bought. But if it's an additional swipe and things like that, yes, the fee would also apply. So I would say, yes, it is quite common. But I think by the sounds of from this question, Nikki, I think this particular owner might have settled without being given a key to the common areas. So I think it's a matter to go back to the vendor as opposed to the owner's corporation, because a swipe would have been provided at one time and it just appears that the previous owner hasn't passed that on to the incoming owner. But if it's the other way around, i.e. the owner's corporation have put in an intercom system and they haven't given any swipes, I think it's only fair that they give the first swipe at no cost, or they exchange it for the number of keys that you currently have. So that's quite common in a lot of buildings where we install a security system and they never had one previously, it was all key. We would say, okay, if you hand in 2 keys, you'd get 2 swipes back. If you needed additional, it would be an additional fee. So I think it's only fair that you would give them the swipes for the number of keys that they had previously.
Can an existing special bylaw be amended without the legal cost of being rewritten by a solicitor? This bylaw outlines permissions and terms and conditions for owners to install ducted split air conditioning systems, roof ventilation, satellite dishes, security screens and pergola roofs, and we would like this to be amended to also include solar panels.
Look, anything is possible. There's nothing to say that you need to get a lawyer to draft a bylaw. However, my very strong recommendation is not to. I'm a big believer that these bylaws might appear to be straightforward, but they are worded in a way that, you know, lawyers are qualified to word. Whilst you might think it's obvious to make the change under the definition of work, so every bylaw will have set out terms and conditions and definitions, and they will always define what works mean, and it will mean, you know, satellite, solar panel, etc. It might appear to be as simple as just amending that definition to include the solar panel work, but there could be other parts in that bylaw that all connect and that also need to be amended. So my strong recommendation is to have a lawyer amend the bylaw as required. Don't try to copy bylaws for other works. Don't try to amend bylaws. That's my recommendation. But the short answer is there's no legal requirement where you must have a lawyer amend or draft a bylaw, but it is highly, highly recommended because the whole purpose of the bylaw is for you to rely on it as an owner's corporation. And if it's not worded correctly, or it's not enforceable, then it's like having no bylaw. You want to be in a position that you can enforce the bylaw if needed. That's the whole purpose of having one.
And I guess they could possibly look at it as an opportunity to check the original bylaw too and make sure that the bylaw that was originally written for the permissions is still reasonable.
Absolutely. It gives you an opportunity to see if there was any other issues with the original bylaw. It's a good opportunity now to amend it, especially because we had changes back in 2015. You know, and where bylaws can't be harsh and unfair. So for me, that bylaw might be harsh and unfair. So it's a good opportunity, as you said, to have that reviewed. Absolutely.
Okay. If an issue in common property leads to flooding in a unit and damaging to the floor or ceiling within the unit, does Strata have accountability to get these items fixed or reimburse the costs incurred to fix it? To investigate an issue reported by the owner of a unit, a tradesperson sent by Strata pulled out some wood from the flooring. Does Strata have the responsibility to fix this damage?
Absolutely. So it's no difference to my car hitting your car, Nikki. I'm responsible for the damage to your car. That's how I always put it, very simple. If the common property has caused damage to lot property, the owner's corporation who is responsible for the common property is equally responsible to repair any damage caused to lot property. Same as if the owner's corporation sent in a contractor to carry out explanatory investigative works to repair common property, it would be the responsibility of the owner's corporation to reinstate that common property as well as reinstate the lot property that it has interfered with to conduct those explanatory works. So yes, the short answer is yes, the owner's corporation is responsible to repair the flooding damage and to repair the reinstatement works required.
Okay, and this question was actually from the same owner, but I've split it into 2 separate set questions too, but I'd say it's referring to the same issue. Can Strata park an issue forever quoting lack of funds? And if common property repairs cost $10,000 to fix and Strata has $20,000 in the capital works account, can Strata park the issue in the pending list citing a lack of funds?
Definitely not. It goes back to earlier what I mentioned before, an obligation for an owner's corporation. So again, Section 106 of the Strata Schemes Management Act states that the owner's corporation must repair and maintain common property to ensure that it's in working order. So if it's failed, it's not working, it doesn't operate, an owner's corporation has an obligation to repair it. Having no funds is not an excuse to meet that obligation. It just means that the owner's corporation needs to take steps to raise those funds. And that's why legislation permits you to raise what they call a special levy. That's above and in addition to your ordinary quarterly levies. So they would just have to raise a special levy to meet their obligations to repair and maintain the failed common property and meet their obligations. So if they don't have enough funds, the short answer is they must raise those funds.
Okay. And this one too is a bit complicated, but we'll run through it and see how we go. An owner has tiled his balcony and installed air conditioning with a visible compressor sitting on the balcony. The owner has not obtained permission, and we do not know if the people who carried out the work are qualified. The owner has not supplied a full scope of works on both jobs. My understanding is that both jobs are minor renovations. However, waterproofing, if applicable, is a major renovation. Apart from no resolution obtained for both jobs, the owner still needs a common property rights bylaw, which I'm not sure we have. We do have a minor renovations bylaw. Are we able to seek, or are we able to ask the owner to supply a full scope of works so we can, in retrospect, approve or decline and thus seek an order to remove both as they are unlawful? If the lot owner intends to sell his unit down the track, he's made unauthorised changes to common property. And what about the maintenance of the common property in case of damage caused by shoddy work?
Yeah, absolutely. So he's on the right track. So for me, I wouldn't say that they're minor renovations because of the waterproofing. I'm assuming if they tiled the balcony, they would have had to put some sort of waterproofing substance down. So waterproofing does need a bylaw. If it was just the air conditioning system and it was installed on the balcony where it's not visible and it doesn't change the aesthetics of the overall appearance of the building, then you could consider it under a minor renovation. The minor renovation bylaw that they've referred to is potentially just permitting the Strata Committee to consider minor renovation applications, because under the Act, a minor renovation application is considered at a general meeting unless you have a resolution that permits your Strata Committee to consider those applications. So I'm assuming that bylaw is just permitting the committee to consider that. Going back to these type of works, they've tiled the balcony. I'm assuming there's membrane and waterproofing. Even if there's no membrane and waterproofing, the tiles are attached to the lot. I would say it needs a bylaw. The air conditioning, I would say if it's not visible from outside of the building, then a minor renovation is fine. But if you're going to have the bylaw for the balcony, I would throw in the air conditioning in that bylaw. You can retrospective approve the application. I would be advising the first step is writing to this lot owner, advising that they've carried out unauthorised works, advising them to make a full application so you can consider the impact on common property or any other lot as a result of these works. And then if the works are in order, the owner's corporation has no concern with the works, then 100% they should be ratifying any approval by way of a bylaw, because again, that is the mechanism in which will protect any shoddy works, any poor workmanship. When an incoming owner comes in, you want to make sure that the owner's corporation is not responsible for those alterations, because when an incoming owner comes in, they'll assume the tiles are common property, as they are in most cases for most schemes, not every scheme, but most. They would assume that the owner's corporation are responsible because there's no bylaw to advise of that. And I think the owner's corporation has a duty of care to ensure that they enforce any unauthorised applications for that very reason, that if an incoming purchaser comes in, they don't want to be in a position of saying, well, I did a search, there was no indication whatsoever on the record. I wasn't aware that I'd be responsible for these balcony tiles. The owner's corporation failed to, pursue the previous owner for the unauthorised works. I've now been detrimented because of it. So I would strongly recommend that this owner be pursued for the unauthorised works. And you can have a bylaw, you can do retrospective approval, and yeah, that's my recommendation.
Okay. We've just got one more from the lot that were submitted. If we've missed anything, if people have sent in emails to us and we haven't attended to that yet, please just resend the email through and we'll get to them. We received so many and it was hard to keep track of what we had coming in. So this one here, an owner of a lot wishes to put in a DA for change of use of a commercial premises in a strata complex that will involve some modifications such as added toilets. As council requires the owner's corporation to sign off on the application before it can be considered, how much detail is the owner's corporation justified in asking of the owner? Can we ask for finalised plans and details, such as the precise nature of the works, including who will perform the work?
Absolutely. So the legislation doesn't have any restriction on how much information you can ask for. The general rule of thumb is you should be asking for everything that you need to satisfy yourself that the works are acceptable to you as an owner's corporation, will have no detriment impact to another lot or the common property. So generally speaking, we ask for all the plans, whether they're plumbing, where relevant, electrical, architectural, structural, depending on the nature of works, of course. But we ask for all the plans. We ask for a detailed letter summarising the proposed changes so that you can then determine if a bylaw is required and what other consents as an owner's corporation are required. So yes, you can ask for any information that you need. There is no limit. That's a short answer.
Okay. Okay, we might move now into some of the questions that were submitted during the session. So please bear with me. I haven't read through these previously. This one here, our townhouse in our complex has a tree growing within their lot that is now covering a section of the roof and contributing to blocked gutters. The unit owner wants the strata to trim the tree to overcome the blockage and associated rainwater ingress. Can you please confirm whether or not it's the lot owner, the unit owner, or the strata's responsibility to prune the offending tree?
That's a tricky one because you have to go back to the strata plan. So the strata plan will generally define where does the common property start and finish, the depth. So generally, they might say that the lot owner's space is from the upper surface of the hard flooring or the tiled surface in a courtyard. I'm assuming there's a courtyard where this tree is located. And then it might limit the height to 2 meters high or 3 meters high. So if the tree exceeds that height limit that's noted on the strata plan, it now then becomes common property. But let's say the limited height is 2 meters, the tree is 3 meters high, the owner's corporation will prune it back to 2 meters. Anything below 2 meters will then be the lot owner's responsibility because it's going back into their lot space. So you'd need to go back to the strata plan, have a look at what the definition of lot property versus common property is for the courtyard and the cubic airspace within that courtyard to determine where the tree sits. Once you determine if the tree sits in lot property or common property, that will then determine the responsible party to prune that tree, assuming the tree is in that private courtyard or courtyard that is attached to an individual lot as opposed to a communal courtyard. If it's in a common courtyard, then the owner's corporation is responsible to prune the tree back.
Okay. Can you please confirm whether owners of a strata property can request directly from the strata insurer to review all claims and payments? I believe you can submit a claim, but we are continually refused to view all activities directly, which we'd like to do. As paying owners, I would have thought this would be possible.
Yeah, so generally the insured is the owner's corporation. So it's the owner's corporation that will have that relationship with the insurer direct. However, everything's got to be kept on record. So this particular owner can actually conduct a search of the books and records where everything that needs to be made available by the secretary or the owner's, the strata managing agent if there's an agent involved. And that includes the claims history. But you could write to your strata managing agent or your committee seeking a copy of the claims history. If they refuse to provide it to you, then you should ask if a claims history is on record. If there is one on record, then you should book in a search of the books and records, and that should then be made available along with all other records relevant to your scheme. And if there isn't one on record, as an owner, you are entitled to view it. I would be asking the strata committee to uplift a claims history from the broker or the insurer direct, place it on file if they're refusing to provide it to you, and do a search of the books and records. But again, they should not be refusing. It is information that as a lot owner you are entitled to. You contribute to the annual premiums. You're an interested insured party, being an owner of the owner's corporation. So I would definitely be seeking that claims history, and they should not be refusing it.
Are all legal costs recoverable when you engage a lawyer to recover outstanding levies?
Yes. So under the Act, that is a legal cost that's very specific. Basically, any debt recovery cost that is incurred as a result of pursuing late payments or non-payments or outstanding levies is fully recoverable. And basically what happens is when we incur those costs, we charge it to the ledger. So any final settlement or final debt recovery process that is pursued by a debt recovery officer or lawyers through the owner's corporation, that would always be recouped at the end. So yes, they are recoverable.
My unit had a water leak coming from the wall and was classed as a strata repair through strata insurance. A new pipe had to be rerouted to the hot water system by digging a trench from the bedroom wall, as well as the concrete floor, and subsequently up the living room wall where the system's located. The water damaged my wooden floorboards in my living area, so the work will be done by the strata insurance repairers to replace the wooden flooring like for like. The Owners Corporation has rejected my first submission to approve the repairs. They say I need to have more research.
Sorry, I lost you there, Nikki.
They say I need to have more research done on the underlay that the repairers will be using, and need to use a foam strip between the floorboard and walls to further reduce any noise transference to common walls. Their response was this was the only way another lot owner had their replacing floor approved. My submission was rejected by the chairman and the secretary before it went up for the vote by the executive committee.
Okay, so
and that's all I've got at this stage.
Okay, but are we saying that the floor was damaged due to a common property hot water? If so, then the Owners Corporation have the obligation to replace the timber flooring, as we touched on before. If common property causes damage to lot property, they're responsible. But are we, because I'm not sure if the question at the end then changed to say that, you know, there's two office bearers refused the application because they wanted to, the applicant is seeking to install timber flooring, and everyone else in the building that was given permission to install timber flooring had to allow for acoustic underlay. So I'm not sure if we're upgrading the timber flooring or we're replacing the timber flooring. So maybe if we can ask that.
Okay, we have got a little bit more information. I'm not sure whether it covers this, but can the chairman reject my submission without being voted on? This would be replacement flooring, as I have had no issues or complaint in regards to my existing flooring. Is this legal? Surely if it should be up to the Owners Corporation or Owners Committee to reject the approval by voting, not just one or two people. Can they stipulate that I must put this foam strip for any chance of my submission being approved?
Okay, so two members can't dictate. So if there's a minor renovation bylaw that permits a strata committee to consider timber flooring applications, then yes, it needs a decision of the majority of the committee, not two members. Assuming two members is not a majority for this particular committee. If, however, they don't have the minor renovation bylaws, then it's not even a decision for the strata committee, because timber flooring is a minor renovation. It has to go to a general meeting. Can an Owners Corporation impose requirements on what they require with the timber flooring? Yes, they can, because it's their duty to ensure that any alterations that they permit to the common property or within a lot does not impact another lot. And as we had a question earlier on today, someone has, you know, installed timber flooring, it's created a noise nuisance. We don't want the Owners Corporation to be in that position because they permitted a lot owner to install timber flooring, and then they've got another issue, which is noise complaints because of that application. So it's very standard, very reasonable for an Owners Corporation to impose conditions around the timber flooring. I've got a scheme because they had a lot of structural issues as part of a defects claim many years ago, that they've got some structural issues that every time an owner applies for an application to install timber flooring or any type of hard flooring, that they have to pay a fee for their consultant to review the application to ensure that the loads on that level won't exceed the tolerant levels, to ensure that the overall weight within that building does not exceed the limit. And that is a requirement that's been imposed by way of a bylaw to ensure that we can enforce it. So short answer is no, it's not unreasonable, but definitely one or two members cannot make that decision. It's either the decision of the committee or a decision of owners at a general meeting, and it needs a majority on either forum.
Okay, there have never been any complaints with the timber flooring, which has been down for 7 years. So that was just a comment from the same lot owner.
Okay, so that means that they're replacing like for like. If they're replacing like for like, in my view, they shouldn't need consent. They're simply replacing old for new.
And thank you for, it's hard sometimes to respond, I know, Leanne, when we don't have all of the information. Thank you very much for responding to that one. We received a delayed strata levy from Strata on the levy. It shows 2 quarters and interest. However, this was sent late from Strata. Are the owners still responsible for this cost?
So interest, they shouldn't be responsible for it. If it was issued late and interest was charged due to the lateness of that notice, then no. But they might want to check if the interest relates to those 2 quarters and it doesn't relate to a previous amount. But no, if it was issued late, they should not be charged any interest.
Okay, this one's to do with smoke alarms with individual units. It appears there's a grey area around smoke alarms within individual units. What exactly is the requirements for strata and the owner's corporation? Is the requirement of all individual units?
Sorry, I lost that last sentence. Is the
stating that they must. So, is the requirement at all individual units that they must be inspected 100%, or is there a requirement that at least 80% is inspected and this is deemed acceptable? Is this a legal requirement or council requirement? If this is part of the owner's fees, should it not then be mandatory for all units to be inspected and receive a certificate?
So generally the rule of thumb is all apartments are inspected. But if it comes down to a small percentage, and I believe it's around about the 20% that isn't inspected, I'll need to confirm that percentage number. If they're not inspected, then they can provide certification on the basis that 80% has been inspected. However, if the following year comes around and the same lots have not been inspected in that 20%, that's not acceptable. So you can't go more than 12 months by not inspecting a specific lot. So if every year the same 5 units, for example, don't provide access, year 2, you can't sign that off as the 20% because they have now not been inspected for almost 2 years. So generally we encourage and we push for all apartments, because once you're ticking the box for the certification, you've still got safety. You've still got owners and resident safety in the event of a fire. We personally push till we get access to all apartments. We don't actually submit our AFSs unless we've inspected 100% of the lots. And sometimes, and in most cases, you'll never get access the first time round. It just means you've got to send a second inspection. We're now putting and implementing bylaws that allows us to recover the cost for re-inspections due to lack of access. So I think when residents are made aware that they are going to be charged for that re-inspection, they're probably a lot more willing to provide that access first round, so they don't pay that re-inspection fee second round. And I think it just comes back down to the secretary or managing agent being very forceful and communicating very strongly when they are issuing notices for access, that access is critical. It all comes back down to the annual fire safety statement. It comes back down to safety. You must provide access. If you don't, you'll be charged X dollars for a re-inspection fee. And we generally then ask our fire contractors to let us know about a week before. If not everyone has scheduled a time, that's where we do ask for times to be scheduled. Not always. Sometimes it's just they're going to be there at that time during and on that date during this time. But for larger schemes, we do scheduling times. So we then work with that fire contractor to say, look, who hasn't reached out yet to make an appointment? And that generally will give us an idea before the inspection day, who hasn't reached out for us to then follow up before those inspections come around.
Okay, and we've had a further question. I'm not sure whether it's from the same person or somebody else that has asked with interest. What is the requirement? Are the batteries needed to be changed every 12 months?
Yeah, so that's a bit of a grey area. That's really more of a question for our fire contractors. The recommendation is to replace them every 12 months, but you get others that sign them off even though they're older than 12 months. So it really comes back down to that fire contractor. And something more specific to fire compliance as opposed to strata. It's not a requirement under the Strata Act, other than you've got to maintain, the building and the fire safety measures. But I know that some fire contractors sign them off older than 12 months. We have some fire alarms that are 5 years old. So it comes back down to that fire contractor.
Okay, we just missed the last sentence there.
Sorry,
Leanne, it just sort of stumbled over. Do you mind repeating?
Yeah, I was just saying it really comes back down to the fire contractor. Smoke detectors, you get some contractors that will sign them off if they're 5 years old, as long as they're working, they've tested them. It really comes back down to the age of the battery. That's what they're looking at. And there's always a date on that battery. Some schemes like to replace them every 12 months, and it comes back down to that fire contractor.
Okay, thank you. And the smoke detector has to be replaced every 10 years. That's a comment that's just come in as well, but.
Yeah, so basically, again, they're checked annually. And if they fail before that time period of replacement, they're replaced regardless. It's the age of the battery, and like I said, it comes back down to the fire contractor.
Okay. All right. Well, that's thank you so much. That's probably all the time that we have today. We have a lot more questions that have come in during the chat, but I think I've copied most of them down. But please feel free if you haven't had an answer come through as yet, just jump on our site and submit your question via our Ask a Strata question page. That's probably the best way to make sure that we do receive it through. But we will try and go through, and if it's okay with you, Leanne, get responses on the questions that we've got outstanding still from today.
Yeah, absolutely. Happy to provide a written response.
Excellent. Thank you so much. So this brings us to the end of the session. Before we go, I'd just like to say a really big thank you to you, Leanne, for spending the time with us today, and also for providing all of that really valuable strata information for our listeners.
Pleasure. Thanks for having us, Nikki, and hope everybody enjoyed the webinar. And like I said, look forward to responding to any other questions that we receive in writing, and appreciate the opportunity. I think it's great.
Excellent. Thank you. Thank you so much. And before we go, I'd just like to ask you, we always ask our presenters if they have any information to share with us or something that they'd like to mention at the end of the session. So I'll pass back over to you.
Thank you. So we are offering a promotion due to this webinar and to any LookUpStrata clients, that anyone who wants to consider Premium Strata for their strata management services, and they sign up or commit to accepting services with Premium Strata by end of July, will provide the first month's management free. So no charges for the first month, and that's offered to any LookUpStrata clients and anyone that's made inquiry through this webinar and signs up by the end of July. So that's something that we're offering due to our association with LookUpStrata. So again, thank you for the opportunity.
Excellent. Thank you so much, Leanne. As always, it's a pleasure working with you and partnering up with Premium Strata. It's been a long time relationship, and we really appreciate that.
It's been great. Thank you. I think it's fantastic what LookUpStrata is doing. It's great value to everyone. Strata can never be black and white. It's very grey, and there's a lot to take in. But it's great to have a platform such as LookUpStrata assist people in property. And it's great to have so many different contributors. And we're very, very pleased to have been contributing for a very long time and continuing to work very closely with you, Nikki. I think you've done great with the platform. So well done, and keep it up. Looking forward to see what else you have.
Excellent. Thank you.
Okay.
Thank you so much for the continued support. And we'd just like to say thank you to everyone for joining us today. As always, we hope to see you at one of our regular webinars in the future. Just keep an eye out for any announcements that we have in the Monday and Wednesday newsletters, and also the magazine. And keep an eye out for the magazine, which is coming out for New South Wales on Friday. And of course, Leanne will be featured in that as always. So thank you very much, and we'll see you next time, and goodbye.
Thank you. See ya. Bye.